Mr. Alvarez.
I submitted a whole bunch of pleadings on Wednesday, which I understood the rule was I could do by Thursday at 1 o'clock. You should have some pleadings in there from me.
What are they? I have a bunch of pleadings from you, Mr. Alvarez. I have your response.
Have you read that, Your Honor?
Yes,
Okay.
yes.
And you consider those timely?
Well, I got them in time. I don't know about Mr. Belenski.
I can tell you that my legal assistant put them out in the mail on Wednesday, and I'll call her. I mean, I called her. I turned my cell phone off out of respect for the court, but I believe that Mr. Lindsay had an obligation. They weren't there Thursday to go to his mailbox on Friday, but that's neither here nor there. If this needs to be done at a different time, I would understand that.
Well, we received matters for filing on December 9th.
Which is Wednesday.
Wednesday. Were they mailed?
They were mailed on Wednesday.
We received them on the same day? I've never heard that.
No, I didn't say that. You see, I said they were mailed to Mr. Belenski on Wednesday.
Oh,
I
okay.
had those hand delivered today.
Oh, all right.
I had those hand delivered to the court on Wednesday just for that particular
All right.
reason,
Okay.
to hopefully give the court more time to read the documents. And if the court feels that this needs to come back another week,
Well,
that's fine by me.
okay, I'll hear your argument. We'll make that decision when we're done here.
Okay. Okay, this is only, I guess the most important thing to understand is that this public comment section is it's only one channel of communication. It's optional. It's only existed since 1992. This is a public comment during the open public meeting held each week by the county commission. Nothing in the law requires such an opportunity to speak in the public meeting. And so therefore, this is what the law apparently calls a limited public forum. The public meeting is a business meeting where the county commission conducts and transacts its business. As such, the meeting needs to be run in a business-like manner with content-neutral rules that further the goal of conducting county business can and should be imposed so that the meeting is useful and productive. Now, in my briefing, there's a case called Chesterfield County, which I believe to be right on point. It comes from the Fourth Circuit. It was cited, as a matter of fact, by Assistant Attorney General Tim Ford, who's the open government ombudsman, and I made that letter that he submitted to the mayor of Palouse an attachment to the Sullivan Declaration. And in that letter, he quotes the Chesterfield County, he mentions the Chesterfield County case. And from the Chesterfield County case is the following quote, local government has a, quote, substantial interest in having its business meetings conducted with relative orderliness and fairness to all, end quote. That same quote goes on to support the idea of reasonable time, place, and manner and regulations. In furtherance of that, the public policy goals since 2000, in furtherance of that public policy goal since 2005, there's been what I would call a preamble that describes what is expected of the speakers. It sets expectations. Many times the chair has been forced to have an inappropriate statement made, and then he reminds the speaker of the preamble, so that it ends up being more of an exhortation than a rule that is strictly enforced and strictly followed. It sets expectations. The preamble has been changed several times, and what is now in dispute is the preamble as it existed in November and December of 2009. The preamble can be best be summarized by the simple phrase, be civil and stay on point. For example, it said, focus on issues, not individuals. For example, it said, no personal attacks or derogatory remarks. For example, it said, please confine your remarks to facts that are germane and relevant to the county government. These texts can be seen in attachments 3 through 7 made part of the Sullivan Declaration. But there's a simple question here, because it's a very narrow legal question. Has the plaintiff shown irreparable harm or substantial injury such that he would be entitled to a preliminary injunction, and down the road perhaps a permanent injunction? The county would assert that the plaintiff has not met this burden and is not entitled to the preliminary injunction or any injunction. And I hope the court will look at my analysis of Chesterfield County, which is most on point, pages 9 through 12 of my memo of authorities. If you look at the behavior of Mr. Steinberg before the Chesterfield County Planning Commission, and what is alleged is a verified complaint by the plaintiff and the various declarants, that case is really on point, because Chesterfield County Planning Commission had in place a policy that said no personal attacks and stay on topic. And when a person couldn't do that, they were struck down. And they said, well, I have the right to speak. And they said, no, you don't. You're not being germane. And once Mr. Steinberg started criticizing one of the Planning Commission members for not paying attention, for being lackadaisical, for not considering an important issue. And the chair said, no, you can't do that. I'm not going to let you do that. And then they got into a tete-a-tete with the member. There was a back and forth between Mr. Steinberg and the person who was accused of being lazy or not paying attention. And the chair correctly stepped in and said, no, we're not going to have this conversation. It's going to break up the disorderly conduct of this meeting. It's not germane, and it's a personal attack. And that's what these rules do. These rules do not create a content neutral. They're completely content neutral. There's even a quote in Chesterfield County that says, certainly people are going to be limited in their speech. But that does not mean that it's not constitutional. If you make a personal attack, or if you do a derogatory statement, or if you go off topic, then you're going to be, then in Chesterfield County, the Planning Commission chair was able to say, no, that conversation is not going to happen. As a matter of fact, Mr. Steinberg got carried away, so carried away that he started to shout. So it was about his tone of voice. And if you read the case even says that there was shouting from Mr. Steinberg, who was the plaintiff in that matter. He eventually got carried away by the police because he would not sit down. So here we have situations where, in the Chesterfield County case, rules that related to being germane, rules that related to no personal attacks, rules that related to we're not going to allow back and forth between the two parties, were upheld as constitutional. And I've given you numerous quotes from that case that describe how content-neutral rules that control time, place, and manner are reasonable.
Well, okay, let me stop you there.
Sure.
Let's assume for the sake of argument that the rules set forth in the preamble are content neutral.
Okay.
What if they're preferentially or arbitrarily enforced?
Well, the facts is presented, that's right. As a matter of fact, I think that's an important point. Let's say facially, those rules stand up.
Let's assume that.
Yeah, and if they stand up, then the plaintiff does not have a clear and legal right to an injunction because he's not likely to win on a facial attack on those rules. But it's very important, as you point out, to discuss the as-applied. That's an as-applied argument. And I think that the as-applied arguments fail. Mr. Belenski was never told that he could not speak about Al Stouff. He was never told that he could not criticize the department head, the individual commissioners, the county administrator, all these people. He was never told that he could not criticize them for failing to enforce the injunction that was in place relating to our unconstitutional sign ordinance. He took it upon himself to say, no, you're censoring my speech. He stopped himself and said, no, I'm being censored, I'm not going any further. There was no action by Commissioner Sullivan that said at any time, you can't talk about that. He was told you have to do it in a polite and civil way, which is part of the Chesterfield County case. Shouting was not allowed, criticizing the man for not paying attention was not allowed, and that's exactly what happened here. The as-applied test fails too. Mr. Belenski censored himself. Larry Carter, one of the other declarants, and again, I have to ask the court how the other declarants, whatever the other declarants did or did not do, I don't know how that affects his violation of civil rights. Well, let's assume for a minute that it has relevance. Larry Carter got in his comment that the county commissioners had allowed the planning director to be all-powerful. Larry Carter got in his comment that all the county commissioners were incompetent. Larry Carter got in his comment that we should attend an open government forum. What part of his speech was censored? None of his speech was censored. The only part that he was told not to talk about was a personal attack on Commissioner Austin, who apparently didn't carry his district during the last election. How that relates to all the county government, I'm not sure. But that was the comment he was about to make, that Commissioner Austin failed to carry his district when he ran for election in 2006. Same thing with Mr. D'Amico. Mr. D'Amico, who actually is filming us right now, chose not to speak. He was asked if he could make a personal comment he asked if he could make a comment about Mr. Stouff, the planning director. He was told that he had to keep focused on issues, not individuals. In other words, keep it germane and keep it above the level of personal attacks and derogatory remarks. Mr. D'Amico, for whatever reason, chose not to do that. So none of these cases amount to an arbitrary, capricious application of that of the